Hi, everybody. So, as some of you may know, I'm currently suing my aunt for money that my dad left. He basically left my aunt as the payable on death beneficiary for his checking account. I was planning on using that money to start a business. Um, he didn't say anything about that, right? I mean, we were estranged for several years, but when I reconnected with him prior to his death, he signed a living trust, naming me as his successor trustee, right? So he reaped all the benefits of me caring for him during his end of life care. Um, I mean, I'm going to go into this in greater detail, but at the end of the day, he reaped the benefits of me being his son, right? He imposed life on me without my consent. He had complete control over me. He raised me. Um, I know a lot of people are going to try to flip that around and say that that was for my benefit. It was not for my benefit. It was for his benefit. It was for his legacy. Um, I never wanted life to be imposed on me in the first place. So, he was I don't know when he named her as the payable on death beneficiary. I'm trying to get that documentation through discovery, which I've already subpoenaed the credit union, and hopefully I'll be getting that soon. But I just want to discuss whether parents should have the right to disinherit their children. I don't think they should. Under common law, there was a doctrine of forced heirship that parents were obligated to care for their children. And just because your children are not perfect, that does not give you the right to disinherit them. I mean, the way I see it, no matter how you look at it, the parents are always wrong, right? Now, my dad tried to blame everybody else except for himself, right? There's a lot of variables that go into it. He can say, "Oh, I didn't raise you, right? You were raised by your mother." Guess what? You picked her, right? You chose to procreate with her. You can say, "Oh, it was the media, right? The media raised my children." Guess what? That's your fault too. You can say that my children were indoctrinated by public education. You knew that when you decided to have children. So no matter how you look at it, whether you raised me or whether society raised me, how I turned out is a direct result of your action. You imposed life on me. This is 100% your fault. Or I'm going to say 50% your fault because my mom is also at fault. But you're jointly and severally liable. You're 100% liable, and so is she. So I feel entitled to whatever you have. For all the suffering that I've experienced on this planet, there is no amount of money that you could ever pay me to compensate me for the harm that you have caused. You did not do me a favor by imposing life on me. And despite the fact that you have made um, a complete mess out of this whole situation, I forgave you, right? I was very angry, and I don't think he even understands that. He still died thinking that I owed him something. No, I did not owe you. I forgave you for the fact that you brought me into hell and made my life a living hell, and the fact that you did nothing to help me when I was in dire straits. So now, I mean, at first I was angry at my aunt because she did agree to sign that money over to my brother and I, but now I'm going to redirect my anger towards him. I'm suing him in death, right? I can sue his estate. And I told y'all that I would do this, right? I told y'all that I would not sue my parents while they were still alive. But if they died, I would sue their estate. I feel entitled to that money. It's not even enough to compensate me, but at the very least, it can make my life a little bit easier. And I didn't even want the money at first, but now that I'm thinking about it, if it had gone to my brother, I would be okay with it. But my aunt, he didn't breed her into hell. He did not owe her anything, right? She's taken a lot of help from him. She took $20,000 from him to start her real estate business, wasted that money. He bailed her out of jail. She's taken a lot of money, and she agreed to it, and then she decided to change her mind. So she's already filed her answer, and her defense basically is that there's a lack of consideration, right? She made a promise to sign it over, but it's not a valid contract because there is no consideration. So basically, she has somebody helping her. There's some type of attorney or somebody involved because there's no way she would know that on her own. So I researched John Locke and what John Locke said about property rights. And I'm not. I mean, I couldn't get the full article, but I'm going to go through this article that I found. Where I think is a good one. It deals with the notion of a forced heirship. Okay, let's see how. Okay, this is what I want right here. Here we go. Testamentary freedom versus the natural right to inherit. Um, this article really deals with no contest clauses. I'm not even going to address that. A no contest clause basically is a provision in a will which says that if you contest this will, then you basically forfeit your right to inherit or you receive $1. That's not. I mean, this is a long article. I think we can skip past that because that's not. Most people are not using no contest clause provisions in their wills. Most people don't even have a will. Above all else, inheritance law in the United States prioritizes testamentary freedom. The law even permits a parent to disinherit his child. Unlike many other nations, no statutory protections from disinheritance exist for adult children in the United States. Disinheritance or the threat thereof imposes great harm on adult children and families. A right to inherit emanates from natural law and should be recognized as such. The natural right to inherit ought not cede to testamentary freedom, but work in tandem through forced heirship, whereby children are guaranteed a portion of of their parents' estate. I think they're entitled to the entire estate. Um, what they're basically referring to is under common law that children had a right to at least a quarter of their parents' estate. Um, and that was with the understanding that the decedent had a spouse. So right, you didn't get the entire estate. Um, the spouse would be entitled to half, and then the children would be, they would divide that up. But if there is no surviving spouse, the children should inherit the entire estate. Disinheritance is often effectuated by court enforcement of no contest clauses. We're not even going to address that because it's complicated, and that's not even the point of what I'm trying to talk about right now. The traditional family is the basis of inheritance law. Some argue that the traditional family has evolved so dramatically in modern times that it is no longer a workable framework. Non-traditional families are now the norm, leaving non-marital children and children of divorce vulnerable to disinheritance. All children, regardless of age, have a natural right to inherit a share from their parents, and that the protections that exist for surviving spouses should exist to all children through forced heirship. Forced heirship will preserve and strengthen the family paradigm, promote social mobility, and is consistent with the law's favor for private markets and limit on dead hand control. Okay, we're going to skip a lot of this. Testamentary freedom is the guiding principle behind succession law and one many important American values. It is essentially the power or right to distribute one property after death to whomever one chooses in any manner. All of the freedoms we value in the United States, including individual freedom and property rights, are limited because these freedoms may not infringe upon the rights of others. By contrast, testamentary freedom permits a decedent to infringe upon a natural right to inherit. Um, that was the understanding on the common law that you had a natural right to inherit. Um, Most states don't have a statutory provision for a right to inherit, but it is still recognized under common law. And I was just researching this before I came online that there's a U.S. Supreme Court case which talks about the right to inherit under natural law, which I'm going to be citing that when I file my amended petition. Um, in this way, the dead hand controls her beneficiaries. Right, that's what they're trying to do. parents are trying to control their children through the grave, right? So you didn't do what I wanted you to do. You didn't tolerate my abuse. So therefore, I'm going to fuck you over. And when I die, you're going to have to fight over my assets. So I get narcissistic supply even after I'm dead. Now, I don't really want to speak ill of my father because he passed away, but what he did was bullshit. And I was directing my anger at my aunt. My anger needs to be directed towards him because he's the one who did this. Um, I did think that my aunt, well, I hope that my aunt would be fair and try to, I don't know, make amends for what my father did. She said she was going to sign it over to my brother and myself, and then she said she's going to split it up. No, 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 no. My brother already got his cut, but once I filed my lawsuit, she decided she's just not going to give me anything, and that's fine. It's not about the money. I feel entitled to the whole thing, and this lawsuit basically gives me standing to advocate for wrongful life because that's ultimately what I'm going to be suing for. Um, it goes into, I mean, this article addresses another option under tort law, but no, I'm suing my father's estate for wrongful life. He imposed life on me without my consent. As a result of his negligence, I have suffered damages, a lifetime of turmoil, and I am entitled to that money. In addition to wrongful life, I'm also suing him for quantum merit. He reaped all the benefits of having me as his son. He got to parade me around like a little dog. He got to control me. He got to raise me. I served in the military to try to honor him. I abstained from a gay lifestyle for many years in order to please him. I've made sacrifices to please him. I don't think that he made any sacrifices. Even the things that he did that were supposedly for my benefit were really for his benefit. It was for his legacy. Um, and he basically used his money to control people, including me and my brother. So it is what it is. I wonder once I file this amended petition if it doesn't get some type of media coverage because this is going to be a doozy. Um, Wrongful life lawsuits are very rare, at least when it comes to antinatalism. There are wrongful birth lawsuits that are pursued for medical negligence, but when it in a antinatalist context, they're very rare. There's probably two notable lawsuits that I'm aware of. Let me see if I have any comments. No comments. Okay. Anyway, let's keep going. Okay. By contrast, testamentary freedom permits a decedent to infringe upon a natural right to inherit. In this way, the dead hand controls her beneficiaries. In many instances, the law limits dead hand control, such as the rule against perpetuities. Um, the rule against perpetuities is a provision under state property law, which says that any property conveyances are invalid unless they transfer within 20 years after the death of the decedent. Again, this article gets into more detail than is relevant for most people's purposes. Um, Yet the law fully allows the dead hand to pervade the lives of beneficiaries without ever having to face the life-altering consequences and family disruption that can ensue. Right, so they're dead. Right, they cause all of this ruckus, and you're the one who has to pick up the piece. See, it would have been so much easier if I never reconnected with my dad. Right, if I did not go to see him at the end of his life, I would say, you know what, fuck it. I never went to go see him. I don't deserve anything, right? But now I did go see him, and I reconcile with him, and I care for him at the end of his life, and I don't, and he basically gave me the false impression that he was conveying all of these assets to me, or into the trust, naming me as the trustee. So that's another thing that I'm going to be suing. Excuse me, I have some mucus in my nose and I have bad allergies, but I'm going to be suing his estate for fraudulent transfer of estate assets. Um, I've been researching the law on this. These are really novel arguments. Under common law, they're not. I mean, it's not like this. There's a whole lot of case law on this stuff, but I'm basically throwing everything under the kitchen sink after my aunt, because under the law, if someone is a payable on death designee, the presumption is that they are the owner of those assets. But you can dispute that, and I don't think I can dispute it by just going after my aunt. I think I have to go after my dad's estate also. That what he did was wrongful. I am legally and ethically entitled to that money morally. He had a duty to provide for me because he is the one who imposed life on me. So I don't think that that transfer is valid. Although we don't have forced airships anymore, um, I can still sue for quantum merit. I can still sue for wrongful life. Um, and then it's going to be up to my aunt to find a lawyer to try to go toe to toe with me. And I don't think that she has the resources to do that. I can do the work myself. She has to hire an attorney. I don't think she can afford to do that. So we'll see. I know she. I don't want to tell all her business because I'm trying to remain somewhat anonymous. But there's a possibility that this case could get some type of media coverage because um, it's a very novel case. I mean, at least the arguments that I'm making are novel. Um, I don't think there's not a whole lot of case law on this. Natural law, as generally understood, stands at the intersection of law and morality. It answers the question of what is the law as it ought to be. Natural law is a theory that the law is fixed and exists independently of what the law may presently be. It is the law of nature as distinguished from the law of man. Philosophers use reason to discover natural law and have at times found conflict between natural law and man made or positive law. For example, the American Revolution was justified in terms of natural law. The revolutionaries argued that the British law, man made or positive law, infringed natural law, individual, self evident, I always say inalienable. I don't know, unalienable rights endowed by the Creator. Um, so this talks about John Locke and his view on natural law. The law presently allows testamentary freedom to override the natural rights of inheritance by permitting a testator to disinherit their children. The natural right of inheritance should not yield to testamentary freedom. Instead, the law should reconcile both testamentary freedom and the right to inherit through forced heirship, whereby children are guaranteed a portion of their parents' estate. The freedom to give property to another or to withhold it, known as testamentary freedom, is a fundamental tenet in American estate law. Courts generally respect testamentary freedom, subject to a few rules. Every jurisdiction opens certain access to portions of the estate, even if the decedent's intention was to block access. Excuse me, y'all. Justifications for testamentary freedom are based on the decedent's prerogative. Philosopher and progenitor of American property law, John Locke recognized a natural right to bequeath. The state of California has expressed that the law should preserve the decedent's intent as it is her property. Um, I don't know. They always say that when you procreate, that you're basically creating a legacy, that you basically gain immortality through your um, descendants, right? That's the whole reason that they procreate in the first place, because they have a fear of their own mortality. Um, so how is it your separate property when you die and you don't leave it to your children, right? You created me so that I could be an extension of you. So, man, these readers are so full of shit, right? If you really felt that I was an extension of you, then you would leave me all your property. But no, you consider yourself to be a separate autonomous individual, which means that I am also a separate autonomous individual. So all the bullshit that you said about me living up to your legacy and you controlling me and all this family bullshit, it's a lie, man. It's a damn lie. It's a scam to try to control you, to say that you don't have any individual rights to live the life that you want to live. You should just do what I tell you to do because you're my slave. I'm your parent, and you should just obey. Disinherited children often opt to challenge the validity of a will. Such a challenge is their only remedy. In my case, there is no will. There's just a living trust and a payable on death beneficiary or designation, excuse me, which does not go through probate. So even if I do a full probate, um, that doesn't go through probate. So that's the reason why the credit union went ahead and gave her the money, because it's a non-probate asset. Will challenges present many difficulties, including the cost of litigation, bitterness between surviving family members, and obstacles in the law itself. Disinherited children have had some success in gaining access to an estate with claims such as a lack of capacity, undue influence, and fraud. Well, I'm arguing fraud, that he fraudulently disinherited me of my natural right to inherit. So, um, good luck with trying to defend that. Such children have found it helps to appeal to the judiciary's sense of fairness and appeal to sympathies. Um, that's what I'm going to have to do. So there's a balance, right? You don't want to go too hard, and you also don't want to go far enough. Um, I don't know how a judge is going to look at me claiming wrongful life if I say that my parents should not have imposed life on me. They're probably not going to be that sympathetic because most people are breeders. The likelihood of me finding an anti-natalist judge are slim to none. Um, I feel entitled to that, but I'm going to have to go in greater detail that I didn't get the help that I needed when I graduated law school. He didn't help me to pass the bar exam. He didn't give me any money. Um, the judge that I have, I'm very fortunate because I think I probably, out of all the judges in that district, I probably got the best judge possible. Um, Judges and juries are more likely to find undue influence or incapacity if the testator's disposition seem unfair. I think this is completely unfair. Um, it's completely unfair. I don't know whether I should let this go before a jury or if I should let the judge decide. Um, I don't necessarily trust juries, but with something like this, I think a jury would most likely think that children should inherit over a sister, especially given her record, all the stuff that she's done, the fact that he gave her $20,000 to start a real estate business, and then she had all these felony charges for adverse possession. I don't think any jury is going to side with her. Let me see if I have any comments. If anybody's still here. Oh, okay. Y'all are still here. All right. Surviving spouses are protected from disinheritance with a guaranteed right to one third or one half of the estate. Some states, such as California, provide protection for omitted, i.e., unknown or unborn children, children of testators through pretermission statutes. Louisiana is the only state that protects living children up to age 24 and all disabled children from disinheritance. The state, through taxes and creditors, are guaranteed what is owed from the state. So this is what I'm suing. I'm suing, or I'm filing a wrongful life action or claim, and then I basically become a creditor. So a creditor can challenge a payable on death designation. You don't get to keep those assets from a creditor. And yeah, I'm going to be a creditor against my dad's estate. This is really ugly. I shouldn't have to do this, but it is what it is. I'm not going to just let her have that money and then just accept it and go on about. No, I'm not doing that shit. I could have just taken my cut and just went about my business, but no, we're not doing that. And the only other money that I'm getting is that my brother and I are going to be selling the house. Um, no, but I feel entitled to all of it. I mean, obviously, I'm going to give my brother his cut, but she doesn't deserve anything. Okay, the state through taxes and creditors are guaranteed what is owed from an estate. These protections impose significant restraints on testamentary freedom by preventing the testator from excluding spouses, omitted children, the state, and creditors from an estate. Yet no state protects all children from disinheritance. Children who are expressly given nothing are largely left without a remedy. All children, regardless of age or need, should be added to the list of groups guaranteed access to an estate with a right of inheritance for the same reason that guarantees exist for surviving spouses. Exactly. I would say that children have a greater entitlement to an estate than a surviving spouse because you impose life on your children. You assume that duty voluntarily. Um, I mean, you also have a duty to your spouse, but I think your duty to your children is even greater. Surviving spouses have widespread protection from disinheritance. All separate property states except Georgia have enacted statutes to protect surviving spouses from disinheritance. Surviving spouse protections against disinheritance are built into the community property system, like California. In separate property states, the common law reflects the notion that a husband is responsible for finances that a wife's responsibility is domestic. Um, I'm going to skip all that because I don't know how long y'all are going to be here. In Louisiana, where the French Civil Code was adopted, a testator may not disinherit a child that is forced heir from an estate unless an exception applies. Forced heir is defined narrowly as a child under the age of 24 or physically or mentally incapacitated. Louisiana allows for disinheriting a forced heir only for specific statutory exceptions. American inheritance law encourages those who have earned real and personal property through the lifetime to provide for their family after death. In light of the social changes that predominate American society, including fewer marriages, blended families, single parent household, and same sex marriages, their traditional family paradigm may no longer be relevant as a framework on which to base inheritance law. Okay, I'm going to skip through some of this because I don't think all y'all are going to be here that long. Um, when deciding to disinherit children, parents may weigh any number of reasons, arbitrary or punitive. The law permits parents to ostracize children because the parent was unmarried to or divorced from the co-parent. Parents may not approve of certain lifestyle choices, i.e., your son is gay, so that you're a homophobic um, follower who basically terrorized your child throughout their entire childhood. and now you want to apologize when a child becomes an adult. Unsavory behavior, substance abuse, or other health needs. Parents may perceive the child as financially secure, not in need of inheritance. Parents may also have concerns about potential misuse, mismanagement, poor advice, debt, or waste. Excuse me. It is questionable whether many children with inheritances truly deserve to inherit. I think all children deserve to inherit. It doesn't matter how misbehaved you were, how disrespectful you were. At the end of the day, you are a product of your parents. They raised you, or they failed to raise you. So, I can't think of any circumstance where a child doesn't deserve to inherit. It is no, okay. Let's skip that. There are several property management options that address such paternalistic concerns without resorting to disinheritance. Any of these same concerns can also apply to spouses, yet surviving spouses are legally entitled to a significant portion of an estate without question. Spouses have the potential to remarry or squander an inheritance. Step parents may completely disavow children of the decedent. Children should not have to earn an inheritance, nor should they lose an inheritance for bad behavior or circumstances outside of their control. A child's natural right to inherit should not yield to arbitrary and unfair exercises of testamentary freedom. Disinheritance can take a psychological and emotional toll on adult children. Um, right. I didn't necessarily want his money, right? Like if he had given it to my brother, I would have been okay with it. But I think he did it out of spite. Um, I was estranged from him, but it was his fault. He's the one who was arguing with me because I bought him supplements for his cancer treatment. He has started arguments with me over bullshit and cussed me out, and I never really did anything to him. I mean, no, I didn't do anything out of spite. Maybe I didn't obey him the way he wanted me to do, but I didn't do anything malicious to him. He has done malicious things to me. Besides the financial impact, an inheritance is a connection to a loved one after death. Right. I feel that I'm entitled to that money. The fact that he gave it to my aunt is a slight against me. Um, and he never said anything. He sat up there and reaped all the benefits of me taking care of him, thinking that I'm going to get some type of inheritance, and he did not say a word. Even when a parent and child were not very close, disinheritance can be very difficult to come to terms with. A disinherited heir may feel hurt, treated unfairly, and betrayed. A will challenge may be the only recourse for these emotional injuries and personal rejection, especially when other siblings, distant relatives, friends, and others are left with gifts. Yeah, and it is a gift for her. It's a windfall. She's going to use that money to go shopping or whatever. I'm the oldest son. He left me as the surviving trustee. It is my responsibility to take care of his estate. Um, my brother and I are trying to make sure that we don't lose the house because somebody has to pay the damn mortgage. She has no connection to his estate. Whatever money she gets is going to go to her. She's not carrying on his legacy. She's not carrying on his last name. She remarried. She doesn't even have the same family name that we have. So she has nothing to do with his legacy whatsoever. Instead of permitting parents to disinherit children deemed as unworthy, states could adopt universally agreeable rules that govern who should be barred from inheritance. Every jurisdiction has adopted Slayer laws which prohibit a child who has killed another from inheriting his victim. I'm not even going to go into that. I don't know how many people are still here. Okay, I have one person still here. Okay. Um, I don't know if I should keep going. Okay, here's the part I want to read. In dicta, the Supreme Court has acknowledged the right to inherit as a natural right. Yet case law continually treats inheritance as a statutory right and privilege. Though the regulation and taxation of estates is inarguably legal positivism, there is no basis to conclude that the inheritance right itself is man made. The right to inherit is recognized by Locke and predates the statutory right to testamentary freedom. In all states and the UPC, the default rule for testators who die intestate is that each and every child of a testator has a right to inherit or an inheritance rights. Intestate law seeks to reflect the probable intent of a decedent by creating majoritarian default rules. And testate law's recognition of the right to inherit is strong evidence that it is indeed a natural right. As the law stands, a child's natural right to inherit can be infringed by testamentary freedom. I want to get into these footnotes. So this is U.S. versus Perkins. Though the general consent of the most enlightened nation has, from the earliest historical period, recognized as natural right in children to inherit property rights of their parents, we know of no legal principle to prevent the legislature from taking or limiting the right of testamentary disposition or imposing such conditions upon its existence as it may deem conducive to public good. Um, and let's get into this next footnote. The right to take property or devise or descent is the creation of the law and not a natural right. Okay, this is what I was telling y'all about John Jacques Rousseau and a social contract, that the sovereign actually owns all property. So when you and I learned this through this another lawsuit that I'm currently litigating, that property rights are basically state rights. It is basically a privilege that is given to you by the sovereign. You don't actually own your property. The state allows you to keep property, but they can regulate it because that property actually belongs to the state as the sovereign. So the state has an interest in preserving the status quo and maintaining order. The state can actually regulate who gets what upon the death of a parent. Okay, I'm losing people, so I'm not going to be on here much longer. Disinheritance can lead to family discord, division, and social and emotional consequences. Popular attitudes suggest that disinheritance is viewed as morally reprehensible and can lead to fracturing of families and fraternal competition. That's what's happening right now. Now I'm having to sue my aunt. I don't know. People are going to have to pick who they side with. They're going to have to side with me or side with her. Since I'm the one who's suing her, a lot of people are probably going to feel that what I'm doing is wrong. But she's trying to take my father's money, and I don't think that she should be allowed to do that. While the decedent is dead and gone, the survivors must carry out dead hand control while dealing with loss. Right? You're grieving over your parent, but you still have to fight over his assets. A dissatisfied heir may file suit to gain access to an estate, causing bitterness and resentment among family, often between surviving spouses and children. Nasty quarrels may ensue, leaving existing relationships broken and hateful. Bad situations involving grief become worse. Certainly, the testator has earned everything that is being left behind, but he cannot take anything with him. The dead hand should not have complete controlling power. Once a testator dies, the interests of survivors should be prioritized. Forced heirship can dramatically alleviate disputes between family members and limit dead hand influence on family relationships that inevitably go on after the decedent's death. Forced heirship was designed to eliminate disharmony among children by limiting inequity inequality that a parent might impose. When a sibling is disinherited, greed can take hold and loyalties can be challenged. Equality through forced heirship can preserve or jumpstart sibling relationships, especially for half siblings adopted children and stepchildren after the death of a parent. The law should enforce a measure of equality among all of a decedent's children. And inheritance can change the course of a person's life, and forced heirship may encourage individual freedom. Such a windfall has the potential to relieve incredible hardships or spur new opportunities. An inheritance can impact one's ability to buy a home, receive an education, set aside for retirement funds, aid in crisis, pay healthcare costs, fund startup costs for a business, and much more. Okay, I'm going to go ahead and wrap this up because I know um, I'm losing people. A guaranteed right to inherit for children of testators would uh, complement, not conflict with state interests, so long as children have a recognized right of inheritance from their parents. The state is less compelled to intervene. A forced share would result in fewer will challenges and less use of judicial resources. Okay, I do want to read this part um, for those who may be interested in this later. Disinherited children may look to tort law to access an estate. The recognized second, the restatement second of torts, and almost half of states now recognize intentional interference with an expected inheritance as a valid cause of action in tort. Um, the IIEI is an alternative to a will contest whereby a beneficiary does not challenge the will, rather she seeks to recover damages from a third party for wrongful interference with an expectation of an inheritance. So I'm going to have to sue my aunt for what is it called? A intentional interference with expected inheritance. A child can pursue relief in tort rather than probate has many advantages. The statute of limitation in tort is longer than in probate. Um, I'm not going to go through all of this. I just want y'all to know that that is an option. I'm going to sue my aunt for intentional interference with an expected inheritance. Um, that's what I'm suing her for, and I'm also suing her for unjust enrichment, and we'll just see how that turns out. But this is the law on this. I'm not going to go through all this because I think this is probably boring and I'm already losing people. But oh gosh, I guess I lost everybody. Okay, y'all. So for those of you who want to go back and look at this, if you have been screwed over by your parents, you can sue them for wrongful life. You can sue whoever got that money for intentional interference with an expectation of inheritance. And I will update y'all when I get more information on this case. But I don't think that parents should be able to disinherit their children. I think you have a duty to provide for your children after death, even if you have an estranged relationship with them. So, with that being said, I'm going to go ahead and end this live stream.